We can record, it's fine.
Hi everyone. Today we have with us Mr. Alvin Antony. He is a techno-legal professional and his area of expertise lies in AI governance, IP and data protection. So today we'll be talking about AI regulation. So, firstly I would like to ask you, why do we require AI regulation in the first place?
Uh, we require AI regulations. First of all, thank you for like inviting me for this talk. It was a pleasure to have connected with you. And to coming to the question, why do you we need a regulation? Is that why do we need any regulation at the end of the day? You go into the commercial side of the things. Let's for a time keep aside things like constitutional law or
Mhm,
criminal law, which is basis of existence of a society. Come into laws like company law or any kind of technology related law. At the end of the day, it's a guidance, or it's a way that you can go when the market itself is not able to
okay,
come out with a particular standard on how you
mhm,
have to work with it.
mhm,
For example, uh, most of the time with respect to artificial intelligence, nowadays what in effect is that at the end of the day, AI is a combination of lot of softwares coming into place. There are like large language models also, but for working
mhm,
there are a lot of softwares in existence, and these softwares, like any other software, may be governed using contracts,
mhm,
digital contracts at the end of the day. That's the general norm. It's not completely true, but that's more or less the general norm at the end of the day. But when contracts are coming into the place, you understand not every party might be in the same shoes to do the negotiation or
mhm,
create a level playing field at the end of the day. And there, to create a level playing field with respect to such a dynamic
mhm,
technology, you require some kind of guidance or some kind of framework in action or set down, so that every player can at least play on the framework that is in existence rather than just going altogether out of the table.
mhm,
So that particular table is the regulation, and for creating that balance in the entire ecosystem or economy, we are saying that regulations are required, and regulations might be hard regulations like proper statutes, or soft regulations like guidance,
mhm.
guidelines, codes, a couple of voluntary other things at the end of the day. So yes, some way or another, this has to be either guided, or guided is one way of
Mhm.
saying it, but regulated is another way of saying. The essence is guiding the people on how to deal with this, and that's all.
So to basically ensure the rights of the users, you'll say.
It's not only the rights of the users.
Okay.
That's only one portion of
Mhm,
the way that market has to develop this technology, use this
mhm,
technology, how the transfer happens. Then there are international jurisdictional requirements. The trade between the countries has to be managed.
mhm.
Essentially, like for a technology like AI, which does not have any jurisdiction at all, effectively speaking,
Right.
it can like have like 10 or 20 different jurisdictions through which the data transfer before it
Mhm,
comes to you for an query that you are asking.
mhm,
The possibility is there. So for that, all these things you have to consider. And my understanding is that when you are asking about a regulation, uh, so most of the time regulations, if you look into AI now, people say that the majority category is like this: there is high risk, unaccepted risk, high risk, like limited risk, no risk, which
mhm.
is like the EU format of regulation
Right.
at the end of the day, that everyone is following with the risk categories. Most of the AI regulations that exist currently is based
Mhm,
on these risk
mhm.
categories. But I feel that that is only one part of it.
Okay.
There are like other ways of like these things. For example, if you look into the basic regulations that Japan as well as South Korea is proposing, it's the as well as Peru also. They are promoting the use of the particular thing. So it's not only the risk-based approach, it's also seeing
Right.
like, okay, there are a lot of good side in the AI also, and for
Okay.
promoting or utilizing that good side, you can do ABC things, and for
Mhm.
that the government is willing to give ABC things.
Okay.
So there is another way of regulation. Now the essence is that you need to get out of the mind that regulation means there is a risk and government is coming and stopping the risk.
Mm-hmm.
That is not regulation. Regulation is, as I said, it's just putting a platform where levels can be made and people can
Mm-hmm.
be playing in a level field. So that's how you have to
Okay.
consider with respect to a regulation, in my opinion.
So I had read somewhere that India is considered to be a country which is for innovation first and governance later. What do you think
Yeah.
about that? And at this moment, do you think we need a separate act of our own, like the EU AI Act, or is there certain amendments are sufficient for now?
I see. I am of the opinion that we need something,
All right.
but is it in format of EU regulation? I am not sure whether it is that, because there are issues like this. There is differences between how India is being considered,
Mm-hmm.
as well as like how, so the market perception of India as well as market perception of EU is entirely different.
Mm-hmm.
So, adopting a law like what EU has adopted and bringing it into India might not be always working out for the well of India at the end of the day. So, there is something like
Okay.
that. Number two, as I said, the risk EU is based on a risk categorization,
Mm-hmm.
right? But in India, we have to go beyond a risk categorization also at the end of the day. You
Mm-hmm.
have to understand that the laws has to be like as I said, we shouldn't create the law because we fear machine.
Okay.
We should create law because we need to have a level playing field of working with machines,
All right.
and that's what we India has to look into if India is planning to create. Now
Mm-hmm.
from the government side, from 2024, I remember reading the minister that time saying that we might not be coming up with a statute similar to the EUA Act at the end of the day, but periodical governance and guidance will be coming from all the sectoral regulator and the center at the end of the day, which we
Mm-hmm.
are actually seeing. The
Yeah.
amount of regulations that we are coming, the amount of, sorry, the amount of guidance that we are seeing, the amount of codes, voluntary
Mm-hmm.
codes, lot of things are in existence at the end of the day. And it's not only that, also even the sector regulators, you look into
Mm-hmm.
RBI, you look into SEBI, you look into
Mm-hmm.
IRDI, you look into TI, even DPIIT is
Mm-hmm.
coming for the copyright related stuff. So all the sectoral regulators also are coming up with these things at the end of the day. The essence that we have to understand why this is
Mm-hmm.
required is that, see, there is an information asymmetry that is
Okay.
existence, which cannot be cured with disclosure.
Mm-hmm.
When I say that, let us say if there is a product, and let us say if an A goes wrong, you can consider it as a product going wrong or a service going wrong at the end of the day.
All right.
Now, because ultimately for the user, it is either a product or a
Mm-hmm.
service at the end of the day. Now, for generally looking into the consumer protection laws of the country, a
Mm-hmm.
consumer is able to show somehow that what went wrong and which caused him a harm at the end of the day.
Mm-hmm.
With respect to AI, neither the end user might be able to explain why it went wrong,
Okay.
nor the
Like.
developer might be able to
Hmm.
say why it went wrong,
Yeah.
nor the deployer might be able
Hmm.
to understand why it went wrong.
Mm-hmm.
So there is a, and this is because of the inherent nature of AI, which we always say and refer to the concept of black box.
Hmm.
And you don't have anything to explore. This is not a commercial secrecy issue. It is actually a techno legal issue that need to be actually have some sort of regulation that needs to be coming into. Number two, let us say in India, most of the victims or most of the people on which the
Mm-hmm.
effect is happening if an AI goes down is the people who have nothing to do with an interparty. Let us say you are a deployer
Mm-hmm.
and there is a developer. You deployed the AI and that has been gone wrong. Someone else has been affected. Is
Okay.
no neither a party of that entire chain of contracts.
right.
So who is going to give benefit to him at the end of the day? And three, the velocity and scale of this is high. For example,
Mhm,
you know the amount of deepfake and AI generated videos that is being circulated in Instagram, social media,
yeah.
everywhere you're right.
Mm,
And things can go viral in like one
mhm,
in couple of seconds at the end of the day. So, irrespective of the fact that you have a law which calls for like takedown,
mhm,
essentially tracking it down and like giving a proper closure to the matter is still we have not achieved. We have so many judgments from court, Delhi High Court and Bombay High Court
mhm,
with respect to personality right protection matters at the end of the day.
yeah.
Still, things are coming up.
Okay.
Still, these videos which has been actually taken down once
Mhm,
has been replicated like a hydra and being coming down again and again.
mhm,
So we are saying that stop it, but it is not giving anyone account, making anyone accountable,
mhm,
or implementing any technological processes
mhm.
that can track and trace and take it down automatically.
Okay.
So these considerations, along with the irreversible social harm, because, for example, if someone's
Mhm,
non-consensual intimate image is being created and disseminated, it's
mhm,
not that someone can pay and
mhm.
the issue will be sorted. The kind of mental harm and mental pressure that person might be going, the harm is irreversible.
Right.
So, given these things and considering the fact of how we are considering the questions of equality, unbiasedness, privacy, all those things, we need something. But it shouldn't be like an EUA Act, as I said, because the EU law, if you look into
Mhm,
Article 35 to 37, it's
mhm.
basically like a product safety statute. You
Okay.
are introducing a lot of product, you do an audit, you do the checking, you get a certification in CE,
Mhm,
and then that can be working whether you are importing or
okay.
developing in the country. Now EU is a big market economically speaking compared
Mhm,
to how India is working. It's a around 27-30 countries coming into
mhm,
the place doing all these things.
mhm,
There is a little bit of development happening and some import is
mhm,
happening. Compared to EU, the amount of deployment
mhm.
is so high in India
Right.
that that we have to have some kind of guidance at the end of the day.
Right.
Now, most of the people who I am having this conversation, they say that okay, let us amend the laws, couple
Mhm,
of here and there, and it will
mhm,
be okay at the end of the day. Sure, amendment might be solving
mhm,
certain immediate issues, but it is
mhm.
not a long-term solution at the end of the day.
So maybe after 5 to 10 years, when there are
Yeah,
more.
maybe for next 5 to 10 years, something has to be there to regulate. In order to avoid absolute anarchy, we may have
Okay.
amendments, but it is not going to solve this entire issues, in my
All right.
opinion, because this amendment is not creating things like the disclosure liability, the
Mm,
logging liabilities, the people who are, for example, if someone is creating a deepfake at the end of the day.
mhm,
Now, I understand that you can have the deepfake to be labeled.
mhm,
Does that law say that you need to disclose if an action is taken, if you need to disclose on from which or platform, which or LLM you are using to create the deepfake? That SGI is being created, SGI needs to be actually like labeled, but it is not
mhm,
telling what is going behind the SGI, how the SGI has to be created, and
mhm,
if that creation is happening, who is being made liable? Let us say if someone is using OpenAI's ChatGPT, whether
mhm,
ChatGPT can be claiming Section 79 exemption from Income Tax Act by saying
mhm.
that someone else put the entry because of that query or prompt it created. We are not generating by ourselves, hence we should be considered as an intermediary and we need exemption. Can ChatGPT claim that? I don't think so. And this is what I understand on the basis of the recent decision from Calcutta High Court in
All right.
this India Mart versus OpenAI, which basically the court itself said that at least in the prima
Mm,
facie stage, you cannot consider this kind of large language models as an intermediary. So there is this
all right.
one issue at the end of the. Now the issue of amendment also you have to consider this in manner. Essentially speaking, SEBI has its own rules,
Mm-hmm.
right? Now the Supreme Court is also coming with their own rules with respect to utilization of artificial intelligence in the court.
Mm-hmm.
And this is only one example of how amendment
Mm,
might going to be affected in a wrong way than in a right way. Is because SEBI rules 16C, the amended version, which
mm-hmm.
says that the person who is deploying it, the person who is deploying it, who might be registered with the SEBI, has entire liability with respect to an
Mm-hmm.
AI system. So it is not
All
on the
right.
actual vendor.
Okay.
It is the person who is deploying it and using it for their purposes who are registered with CB, irrespective of the fact that whether they are developing it or not, they have the liability.
All right.
The Supreme Court rules, if you look
Mm-hmm.
into the language, it's constructed in a way that it goes to the vendor,
Mm-hmm.
might not be even touching upon the deployer at the end of the day.
Okay.
So it is technically going in two different ways, and amendments
Mm-hmm.
always have this risk. So one set of law getting amended without even checking another set of law
Mm-hmm.
might be effectively making a complexity that first of the users might not be having, they might
Mm-hmm.
not know where to which all laws I have to claim under.
Mm-hmm.
Number two, it creates more uncertainty that the commercial parties might feel not very confident in investing in India.
Right.
The more little regulations, which means that more money for
Mm,
enforcement, more things to be checked, more man hours to be employed for
mm-hmm.
making sure that 10 different laws now coming into the place, and that's going to be a complex situation at the end of the day. Simplest example I will say,
Mm.
what did the ANI versus OpenAI talk about the section 52 exemption,
Yeah, fair
right?
use.
It said that there is a fair use exemption in certain circumstances. The
Mm-hmm.
court said that there is fair use exemption. Couple
Mm-hmm.
of months before, the DPIIT said that we cannot give the TDM exemption. We are going for a kind of like a kind of what we have copyright society. There will be
Mm-hmm.
a society related society. There will be licensing on the basis of that. Now the court is going on one way, and the DPIIT proposal is going on the other way.
Right.
So, simple amendments, in my
Mm-hmm.
opinion, might not be the best way.
Mm-hmm.
And one more thing, I forgot, but this is very important, is the fact that we have something in Section 8(5) of the DPDP Act,
Okay.
which talks about the completeness, accuracy, and consistency of the personal data that is used for processing.
Mm-hmm.
But we don't have something similar to Article 22 of GDPR,
All right.
which says that if a person want not an automated decision to be taken upon him with the help of any such thing, automated decision, he has a choice of not doing that. So in India, we don't have a choice of opting out of this automated decision.
All right.
So all these issues in comprehensive, you understand,
Mm-hmm.
there is a lot of issues at the end of the day. So that is why I say that we might need to have at the end of the day a regulation that
Mm-hmm.
is not like EU,
Mm-hmm.
but not in a form of little amendments, but
Mm-hmm.
something that can consolidate entire thing or
Mm.
give power to a single structure. Let us say any particular organization or sectoral regulator comes and say that I am going to make a rule and regulation in this manner. They need to at least check with the
Mm-hmm.
similar kind of organization which might be impacted by such a rule or regulations. Now, this is actually proposed by the office of principal scientific advisor in this techno legal related working. There was a white paper on that. There is a proposal for that to create
mm,
TPEC as well as the AA
mhm,
governance guidance group in the central level, which act as one single platform. But
mhm.
for making them effective, we need to have some kind of statutory thing. That's my opinion.
Got it. So basically, you're saying that until we don't have an act or some guidelines, then there will be a lot of legal ambiguity.
Yeah, see, I won't say that we require it at this moment. Immediately, we need to make
Right.
something so that, and but we need to have some sort of see. If you have a single long-standing pole, everything
Mhm.
can be structurized.
Got it.
Now it is happening
Mm.
unstructured, fragmented. As I said, SEBI has something different,
Yeah.
RBI has something different, IRDA has something different, DPDPA is going on a one
Mhm.
different way, Supreme Court is going on another way.
Mm.
Not really think from the perspective of the consumer, think from the
Mhm.
perspective of companies also, especially the
Mm.
SMEs in the country.
Mm.
The amount of confusion, their one particular AI model might be able to be used for two or three different things, but
Mhm.
these different requirement of different sectors make them essentially restrict themselves to one particular sector,
Got it.
because this particular sector's requirement and that particular sector's requirement might be entirely different, and the companies might have to customize their technology based
Mhm.
on that. So that is why, in my opinion,
Got
you
it.
might be requiring a single standalone thing to make sure that there is harmony between all these
Mhm.
things at the end of the day. So yeah,
Got
maybe
it.
maybe we should look at it.
So you also mentioned about black box situation, and even recently in the draft regulation for use of AI in courts, this was explicitly
Yeah.
mentioned by the court. So do you think black box should be inherently banned?
See, specifically, I am speaking from the perspective of, let us say, this Supreme Court's draft regulations.
Right, sir.
I don't think that black box in itself is the problem.
Okay.
It's basically if you are able to come up with a decision even using black box,
Mhm.
are you able to substantiate the logic without the results that you obtain from black box? For example, let us say if you are using a particular AI model to create something, and ultimately
Mhm.
you created something, and finally you write your own logic.
Mhm.
If your own logic stands independent of what the AI created,
Mhm.
then that makes the whatever the AI given you
Okay.
is as a research material or something like
Mhm.
that. The problem that we are now facing is that that independent logic is being reduced because of the echo chamber that AI is creating even in the minds of lawyers.
Mhm.
AI might be creating something very fantastic. A lawyer might be. I'm not even like talking about lawyers. We have already had one decision from Honorable Supreme Court where the NCLT's orders were
Mhm.
like actually recalled because they were found that AI was actually used.
Mhm.
So there are actually instances from Honorable Supreme Court that like
Mhm.
this is happening. So banning black box is not a good strategy. Even if you look into this, in the world, there
Mhm.
are very limited amount of white box systems as well as gray box systems.
As in
White
fully
box is like
transparent.
as in fully transparent,
Yep.
and gray box is like semi-transparent. You know little bit of things, but not like
Not
everything.
really.
Now, in the commercial side also, you have to see
Mhm.
someone is putting like too many effort, too many money, too many time and everything for at the end of the day. Then you are basically saying that okay, no, you have to make it like disclose. I don't
Mhm.
think that is a very much commercial support also. Like no one will have any interest in making this system at
Yeah.
the end of the.
Mhm.
So you need to consider how this has to be there. Now Supreme Court is very serious about like certain things,
mm,
like transparency obligations they were like speaking about. They were talking
mhm,
about this not using for certain categories of their things at the end of the day. So instead of like completely banning the black box, in my opinion, this accountability and transparency, when there is actually something that is being used, there should be some way of transparency coming into the place, in my opinion. Now this is again debated.
mhm,
The Supreme Court's Advocates Bar Association, they said that if an lawyer is actually checking it and verifying it and signing it, there is might not be requirement of saying that AI was used in drafting or preparing any
mhm.
document.
Okay.
But in that case, the amount of liability should be putting on lawyer should be super high rather than just
Yes.
on a couple of words.
Mm,
If he is checking or if he giving an affidavit that this is verified, and if it turns out to be AI used and it is causing any issue, it's not only that, even the data that is going into an AI system, if that code leaks at the end of the day,
mhm,
and because you don't know once it is in the black box what might happen, it might be spilled over and a lot of things. So maybe you should put or stress more on the accountability and transparency questions rather than just asking the questions. Apart from a couple of things which the guideline is saying about
mhm,
banning, like not using, for example, like this thing, bail consideration,
mhm,
uh, correction requirement and everything, because we already have issues or like examples of bad use of these things. An example prominently everyone discuss with respect to that is the
mhm,
compass in Wisconsin, which was
mhm,
actually used for the bail
mhm,
consideration and everything. That had a very big issue because to like a particular reason at the end of the day. So these kind of things you might have to consider at the thing that like the explainability, even what you are doing
mhm,
it, like what you are saying that I am using it and everything, I think that should be replaced with evidentiary mandate. If you are doing a particular
mhm,
using an AI in a particular manner, you are supposed to have like records of what kind of data was used, how
mhm,
the processing happening, what kind of prompts you might be using, what
mhm,
kind of language model, which version. Like Claude itself has like 4 or 5 versions that is available currently. Chat GPT has another thing. Have you used a publicly like general AI model like
mhm,
ChatGPT or Claude or Perplexity, or you are going into legal specific things like
mhm,
jurisprudencia or something like that? So those kind of things needs to be corrected. In my opinion, that should be the way it has to go rather than completely
mhm.
banning the entire black box system. So that's the area that we need to think more at the end of the day.
Okay. So from what I know, India introduced its own AI guidelines in 2025. So do you think that Indian organizations have like started some AI governance, some practical steps toward AI governance or not?
Let me be very frank with you, and a
Okay.
lot of people might be not agreeing with this. But the reality is that even in India, the AI governance kick in when a foreign contracts come in, not because we have a guidelines in existence
Okay.
at the end of the day. Like let's say a client from California come and they say that they need to, sorry, a client from California or let us say somewhere from Europe come and say that you need to follow this particular standard, let us say 42001 of ISO
Mhm,
for AMS, because they have an obligation under the EU law.
mm,
So unfortunately, the Indians' a mentality is that until and unless something is hanging over their head, we might just pass it on, pass it on, pass it on. Like
yeah.
so just having an AI governance guidelines is a good thing. I'm not
Mhm,
saying that no organization is taking it, but
mhm,
rather quite some amount of organizations are doing actual job, but not enough in my opinion. Majority, at least 90 percentage of the organization, the AI governance questions actually start up when the contracts used to come in. So the first thing that we have to do is to change that narrative,
mhm,
make people understand that having a proper governance can give you benefit for the commerce also, rather than just saving you from the regulatory sanctions. Because in when you actually execute these things, you will understand about the assets, you will understand about the business opportunities, you understand
Okay.
about the client relations, vendor relations, what kind of risk you have to take, what the risk the vendor has to take at the end of the day. All these questions become clear when you have a proper governance plan with respect to artificial intelligence at the end of the day.
All
For
right.
that, you need to for and before that also, in my opinion, literacy
Mhm,
is very important. A literacy.
mhm,
People think that I know how to write a prompt, I am a literate. That is not a literacy at the end of the day. You need to understand like what all are the kind of regulations that is existent, what I supposed to do if something happens like this, or what is the extent to which I am able to
mhm,
use the AI, for what purposes, what is the best model I have to use,
mhm,
are there any global regulations that I have to follow. There are a lot of things, choice of the
mhm,
technology, choice of the forum at the end of the day. So those things that you have to like do it. Even saying all these things, I will say that one sector has done it well, which is
which
the
one?
banking and finance sector.
Okay.
Banking and finance sector. Because not only because they have this thing with respect to the AI governance guidelines, the RBI as well as the SEBI, all these things, they have a lot of audits to be considered. They have a
Mhm,
lot of technology integrated for quite some time at the end of the day. So for looking for all these things, they are actually doing fantastic job in executing AI governance, the free AI governance guidance. In fact, it is very interesting to see that usually what happens is that there is a national technological policy, and sector-wise adopt
mhm.
it from the national technological policy. But in the banking and finance sector, if you see, the seven sutras and all these pillars and everything was actually first given in the free AI report of the Reserve Bank of India, and that was then adopted to a sector agnostic national framework.
So basically, Government of
So,
India
which
is learning from RBI.
no, it's not like that. But in a way, if you
Yeah,
have
got
to
it.
put it, it is correct at the end of the day. So that is
Okay.
one way of like using it. Um and then that is what also, and RBI also is giving couple of things at the end of the day.
Mhm,
They have like classifications. Even they recently come up with this I think model risk
mhm,
management framework. So that is something that RBI is doing. So RBI is doing fantastic job, and I think if anyone has done the governance with respect to
mhm,
artificial intelligence properly, that is banking and finance sector at the end of the day. So yes, there are some people who is doing fantastic job,
mhm,
but we need more sectors to come into the place to have this kind of accountability created, checks and balance created, kind of functioning created, kind of timeline implementation created. That only makes this AI governance guideline
mhm.
proper or like
Okay.
useful.
Yeah. So from what I understand, as you also mentioned that when, let's say, there's a US firm, then there will be proper AI governance, right? So AI is inherently cross-border. So when we talk about regulation, do you think even with AI there will be international AI governments as similar to Paris Agreement for climate and aviation standards?
Well, I will say that there might be an. It is good to have an international regulation, but it will be tough. And when I
Mhm,
say that it needs to be a regulation, it is not something like a
mhm,
proper way of legally binding. You have to do ABC things, then only we will
mhm,
be having, because the geopolitical issues of AI is completely different than what you see in the aviation industry or in the climate industry at the end of the day. AI is essentially something similar like a nuclear technology,
mhm,
which has a very good side as well as it can be going to a very bad side also at the end of the day if not used properly. If you look into the aviation side, aviation was able to like have these international understandings, and regulations are based on couple of things at the end of the day.
mhm,
First of all, if an airline goes on the air, it needs to land somewhere. There is
Right.
nothing like that, and it has like people being carried at the end of the day. Some people are okay to get you landed, some people
Mm-hmm.
are not, and based on that the arrangements can be made between the parties. If
Mm-hmm.
something goes down or something goes wrong, there is an independent like a checking that is being considered, mostly by saying that if an accident happens, this checking or audit of what it goes down or wrong, that might not be able to be relied blindly in civil suits. So that is one of the winning point of aviation industry, that there is a lot of checks and balance
Mm-hmm.
happens. You need to understand when the investigations happen, what goes down, and the industry adapts from it to
Right.
make the entire industry working for everyone, for transportation, business, and everything. Because making the technology bad will cost the industry more.
Mm-hmm.
AI is not like that at the end of the day. Good or bad, if the industry is good or bad, it doesn't really matter to a lot of people. At least I will say the bad actors,
Mm-hmm.
and the amount of bad actors in AI industry is considerably high compared to the aviation industry.
Okay.
So, on the basis of how, if you are saying that based on AI, we had the aviation industry, it was based on standard, it worked well, and AI should be following that. I don't think that's a correct way of putting it, given the entire differences
Mm-hmm.
between the aviation industry. Climate is also not a very good comparison to the AI industry. At the end of the day, we have lot of regulations, not a lot of agreements, putting
Mm-hmm.
that lot of organization. But effectively, what does all they do? They don't usually create these independent studies based on which the
Mm-hmm.
people are learning and implementing it at the end of the day, because climate interest of different countries are different at the end of the day. So aviation industry, in my opinion, was a success with having a
Mm-hmm.
parity in the entire world. But climate is not a successful in like consideration with respect to that. AI needs to be balanced, in my opinion, because even today, if you are speaking, the countries which has the power to develop the most powerful systems are only handful,
Right.
right? And even the people who are having the resources to build the hardware is only a handful. Now we are like seeing there is lot of division happening between the west and east, where US and EU leading one block and creating a lot of things. Even the hardware control is created by pac silica. There are like the framework convention that is put by the European Union with
Mm-hmm.
respect to legal binding nature. And the end of the day, on the other hand, the China is also coming up with the
Mm-hmm.
WAIO. See, with all those countries which are saying that okay, you are not giving us entry, it doesn't matter, we are making our own block at the end of the day. And everyone wants to be the boss in this situation, so
Mm-hmm.
it might be very hard for a a globally
Mm-hmm.
acceptable uh, thing like what we see in Paris Convention or anything with
Okay.
respect to AI. There is high division at least for next 10 to at least next 20 years. I don't see all these issues
Mm-hmm.
coming up in a proper solution where everyone will sit down and do it. The UN is actually doing something great, because
Okay.
now UN is actually building this global dialogues. We have GPAI. There is this scientific panel of UN with respect to how AI is being considered. So UN is having something at the end of the day, but most of them are for the study and the
Mm-hmm.
development. There is nothing which is stopping on like looking into the liabilities of not giving access to certain things
Mm-hmm.
from one country to the other country, or something like developmental support for the least developmented nations with respect to the artificial intelligence.
Mm-hmm.
Nothing like that is being considered. So if you are building something, it is very hard to be uh, considering everyone's interest, Only
Okay.
there is a high chance of only some countries' interests will be considered in a global norm for artificial
Okay.
intelligence, which might be catastrophic to other countries at the end of the day. So I don't, though I wish that we have something like Paris with respect to AI also, the possibility of utility with respect to something kind of that is binding upon the countries to act upon for the betterment of tomorrow. The current market, after observing current market, I don't think it's a plausible thing at the end of the day.
So
But
at max, yeah. Okay.
I wish something like that comes up.
So the best realistic possibility is individual agreements and treaties with respect to AI.
Mostly the trade agreements or
Okay.
the blocks that they are coming, because for example Pax Silica India also joined at the end of the day, which is very
Okay.
important for the development of chips. And as you know, the most people think that large language model development and all those things are the most important fights, but at least in next 2 to 3, no, even if you started now only, if you look into the biggest fights are happening with respect to the control of chips, as well as
Hmm.
with respect to the infrastructure at the end of the day.
Yeah, there was a lot
so
about
so
sovereign
those.
AI from what I've read
Yes,
recently.
sovereign AI also there is a huge fight. First of all, there is no consensus on to what extent you call some AI as a sovereign AI at the end of the day. Because I remember that reading somewhere said that you prepare the entire stack of like development to deployment to use and like everything in that is under the control of one particular nation, that can be considered as a sovereign AI thing. But then there is another way say that you purchase everything from anywhere, doesn't matter where you are getting it from, you have the final output control with a particular country, that also can be considered as a sovereign AI, which is what India is claiming now, because
Okay.
India don't have that much compute
Yeah.
or the chips at the end of the day. So sovereign AI is a topic that is still disputed because we don't have a
Okay.
single understanding of the term. It is different to different people or
Right.
observers at the end of the day.
So I guess with this we have come an end to the discussion. It was great to talk to you, and I got to
It
learn a
was a
lot.
pleasure to having a conversation with you also. Looking I hope I cleared
Yeah.
something, and the viewers will be able to think from what I said, and
Okay.
able to understand something beneficial. Thank you.
Thank you, sir.